Ladies and gentlemen, it's my great pleasure to introduce Lyn Ulbricht today. I met Lyn for the first time last year at PorcFest. She had come out, she had heard about the Free State Project and this event that we throw every year, which is a celebration of liberty and freedom. And we were sitting down by the tent, and her phone rang, and Ross was calling from jail, and I had a split second where we got to say hello to each other, and I think it's a memory that will always stick with me. Lyn is a wife, she's a mother, she's a freedom fighter, and she is a tireless champion for her son and the Fourth Amendment. Please join me in welcoming a hero for liberty, Lyn Ulbricht.
Thank you. Ross just called me a couple of hours ago, and I told him how much love and support there was for him and me here and how much it meant, and he was so encouraged by it. Thank you so much, Carla and everybody. It's been a real privilege to be here with you. So, my son Ross has been in the spotlight quite a bit the last year and a half. So today I want to redirect that spotlight to another major player in this case, namely the United States federal government, and show you why I believe that they and how they operate is far more dangerous and a larger threat to our liberty than any one man or website could ever be. And this case is not just about Ross or the Silk Road. It's not unique to him. It's really a case study in how the government prosecutes and convicts someone using all nonviolent charges, a nonviolent person, and virtually condemns them to a long death sentence where they literally rot in jail until they die for something they did when they were 26 years old. Basically buried alive. The Sentencing Reform Act requires that a sentence is sufficient but no longer than necessary. But Ross was sentenced to a more severe sentence than most murderers, rapists, kidnappers, child pornographers. It's a harsher sentence than Charles Manson gets because he's in a state system where there's parole. Ross doesn't get parole. Now, I know there are dark and unsavory things on the Silk Road and on the internet itself. But while a lot of media and people are looking at all that stuff and that's sensationalizing, over here very quietly, there are precedents and other very important issues that are not getting the attention they deserve. And as Paul Joseph Watson said, the government is using this case as a Trojan horse to sneak in precedent that, in his words, will eviscerate internet freedoms and set the precedent for chilling new laws that would drastically change the face of the World Wide Web. Now, I can't cover all the things the government has done in this case that I object to because I just don't have enough time. It's a really long list. But I'm going to touch on a bunch of things, and I think you'll get the idea. So first, when Ross was arrested, technical challenge. Sorry. He was immediately put in solitary confinement. This is a person with no priors, no history of violence, and there was no explanation. He was in there for 6 weeks. Now, I guess I can see a justification for solitary if the person's a threat, but otherwise, I do not see that it has a place in a civilized society. Basically, it is torture, pure and simple, and if you think I'm exaggerating, please Google it. Right now, from what I've read, there are 80,000 people here in the land of the free in solitary. Some of them have been in there for years, and some even for decades. So we immediately started to work to get Ross out on bail. And friends and family gathered together who knew Ross and wrote over 70 letters. It was a record number in our attorney's long career. 27 people stepped up and pledged houses, life savings, money, whatever they had towards Ross's bail. And these were not wealthy people. And we raised $1 million in pledges. In addition, 17 of those people signed the bond, which means that if Ross skipped bail, they would be responsible for the entire amount. So with those letters and those pledges, we thought we had a pretty strong bail package. And besides which, the Eighth Amendment strongly supports the tradition of bail. They do make there is an exception often made for if the person's dangerous. And that's exactly what the prosecution alleged. And they used their allegations of murder for hire to say that Ross was way too dangerous to release into society. Now, I think of someone who's dangerous as someone you're afraid to get into an elevator with. Well, you would not mind being in an elevator with Ross, and in fact, he'd probably hold the door open for you and ask you what floor and punch the button for you. Needed it. To say that Ross is dangerous is absurd. But that's what happened, and he was deprived of bail, and yet, 2.5 months later, the same prosecutor did not indict him for murder for hire. Suddenly, that was off the table, but he was deprived of bail, so it served its purpose. So Ross was in prison, and of course he became a model prisoner. He taught fellow inmates, he tutored them, he had a yoga class, he had a physics class. Right now he is teaching a GED class so they can get their high school diploma. 3 of them wrote letters on his behalf to the judge for sentencing. He helped 3 of them get into college in a correspondence course. He's been nothing but an asset. A guard came up to me and literally gushed about how Ross, what a great person he is. And in fact, there's someone here who met him in prison who came up to me last night and said what a great guy he is. In any case, he was given permission by the court to participate in his own defense by reviewing the discovery evidence that the prosecution had. And what he needed was a laptop and the evidence on CDs, and of course the software to read it, which he didn't get. We didn't have the software. And then the laptop would break. And then it wouldn't be returned, and when it was returned, it was broken. And it just became a saga of useless software being buried in data, 4.5 terabytes, where you have to find the needles in a haystack. Just one delay and obstruction after the other. We had to go back to court again and finally eke out over time this evidence that he had the right to see. In addition, the bureaucracy of the prison was difficult. One day a guard might go, no, you can't go down and look at your laptop, arbitrarily. There were many days where he had to choose between eating and reviewing discovery, because if he left, he couldn't get back. And I remember one time I was visiting him and he goes, get me something out of the vending machine now because I'm starving, kind of thing. So, and then this sort of thing continued right up until trial. There was what's called the 3500 material. This is material the government had for over a year. They waited until 10 days before trial to dump 5,000 pages of it about one witness, and then 3 days later, a week before trial, another 2,500 pages. That's 7,500 pages to review a week before trial. And apparently, according to our attorney, Ross's attorney, this is what they do. He said, criminal trials are conducted by ambush. The prosecution withholds as much as possible in order to deprive the defendant the opportunity to rebut, to defend himself. This is our government. Another thing that happened last minute was that normally the defense is provided with the witness list of the prosecution weeks, sometimes months in advance, so they can review it, they can research, they can prepare their cross-examination. But the prosecution said, well, no, Ross might intimidate or even murder these people magically from prison when he has no email and his phone is monitored and his snail mail is monitored. So he can't have that list until the Friday before the Monday of trial, and the court upheld that. So he didn't have the witness list. Another hurdle is that this case has had a lot of political pressure on it, mainly from one of the most powerful politicians in the United States, Senator Chuck Schumer. It's called Schumer's case. So even he's the one that called for the takedown of Silk Road initially. And even though Ross was arrested in San Francisco, funny, he's being tried in Schumer's state. The prosecutor, who's the head of the whole thing, is Preet Bharara. He was Schumer's special counsel for 2 decades. The presiding judge in the trial, Catherine Forrest, was recommended by Schumer for her position. Schumer came out before trial and basically convicted Ross publicly by saying in an open letter to Eric Holder, hey, congratulations, DOJ, for getting your man. And I was shocked. I'm like, wait, I thought we had a presumption of innocence in this country. Here's a United States senator trampling all over a basic tenet of our justice system, which is innocent until proven guilty. Also before trial, there were a lot of questions about the server. One of the things that I noticed a couple of times is that I question that the government is honest in its statements. And one of them was it went to magistrate judges after the server was seized and applied for other warrants emanating from that seizure. And it said, we don't need a warrant for the original seizure because we have a mutual legal assistance treaty with Iceland. And so they got their various warrants. And yet a few months later, in their rebuttal, in a little footnote on page 3, it said, oh, you know that thing about the MLAT? That wasn't technically correct. Actually, we don't have an MLAT with Iceland. Now, this was made under oath in several times. Another statement made under oath was by FBI investigator Christopher Tarbell, who claimed to have found the Silk Road server, and he published how. And immediately, experts all over the world said, no, that's impossible, that's gibberish, it's basically it's a lie. And Tarbell said, well, I would show you, except darn, when the prompt came up, I said don't save. I didn't save my work. Just trust me on this. Apparently the judge did. Whoops, went the wrong way, sorry. Christopher Segoyan, the lead technologist at the ACLU, put it this way about the server. There's something seriously shady going on in the Silk Road case. He tweeted that. So finally we get to trial, and that would take two more talks to go into in detail, but I'd like to touch on the third and fourth day and show you what happened. It gives you an idea. So, the third day, this man, DHS, Department of Homeland Security agent Jared Dryagan out of Chicago, was cross-examined by Joshua Draytell, Ross's attorney. He had spent thousands of hours, 2 years, as an undercover agent on Silk Road. He's also the agent that when the day Ross was arrested and he was in the library and Ross was downloading the Colbert Report off an open source network, he's the agent that messaged him and said, hey, could you get on Silk Road? And according to testimony, Ross did. And what came out in the cross-examination was the following. Dryagan had thought, and he testified, that he thought several people used the DPR handle, but he was honing in on one of them, Mark Karpelis. And not saying I'm not passing any judgment on Mark Karpeles. I'm just saying this is what happened in the trial. He had a big file on him. He was honing in on them and suspected him. He had stated in 2 sworn affidavits that he had probable cause to believe he was DPR. He was seeking a warrant for his Gmail account. And he also asked other agencies, please don't tip him off. I'm about to close in on the guy. But DHS Baltimore, Maryland, which we will see was the site of extensive corruption, did tip Karpeles off by seizing over $1 million out of his account. And Derjagan was quite upset, actually. And then we learned that Karpeles' lawyers approached DHS Baltimore, Maryland, and said, look, we've got a deal for you. You back off our client Karpeles, and we'll give you a name. We'll give you DPR. We don't know what else happened at that meeting. What we do know is that 2 weeks later, Ross was arrested, and Mark Karpeles has never been charged with anything. And that was the first time, by the way, that this man, Derjagan, had ever heard of Ross. Okay, then at that point, the prosecutor leaps up. Objection, objection, this line of questioning must stop now. We can't go forward in this. And the judge didn't quite get it. She's like, well, why? You know, and she's like, look, I'm here and you're here and you need to show me how we can work this out. And he kept arguing, and finally she said, let's stop the cross-examination. Our lawyer had at least another hour to go, he said. Send the jury home early so we can talk about all this. And that's what happened, and she said she was doing this in the interest of justice. And so the prosecutor kept arguing and said, look, they want to say someone else is DPR. And she's like, well, yeah, that's valid. I mean, what else do you do? That's what a defense does. And at that point, our attorney cited the Brady rule, which is a well-established law that says that any evidence in favor of the defendant cannot be hidden, and the judge agreed. It was Brady. And she went on to say that if the agent, Derjagan, pursued someone other than the defendant, it was highly relevant, and not only that, it was directly relevant. And how he arrived at that conclusion was obviously relevant. The fact that the agent believed there was probable cause to suspect him, clearly relevant. That the agent believed somebody else might be DPR, obviously highly relevant. And that an alternate suspect strikes me, her, being the judge, as in the heartland of the defense. And the fact that Karpeles could be a DPR had, quote, come out in spades. When the prosecutor continued to argue, she said, look, this Karpeles thing, the cat's out of the bag. Court's adjourned till next Tuesday. It was a long weekend. Well, we come back, and it was like I was in a different courtroom. Now we're playing by different rules. All those relevant things, now they were irrelevant. The jury was told to forget they ever heard it. The prosecution got a mulligan, and the judge flagged what should have been objected to and wasn't, so it could be sustained. And very strict boundaries were set going forward as what the defense could ask. So, did you suspect Mark Karpeles? That was now off limits. Did you believe Mark Karpeles was DPR? Off limits. Do you suspect that Mark Karpeles operated Silk Road? Off limits. And that offer from the lawyer to provide DPR's name? Well, that's just not relevant. So here's day 3 versus day 4. What a difference a weekend makes. So the cat was back in the bag. And the reasoning, you know, this alternate perpetrator thing, that just might confuse the jury. We don't want to do that. And our lawyer said, my whole cross-examination and defense is eviscerated. Or as Forbes' Sarah Jong wrote, completely derailed. And that wasn't all that happened. The defense witnesses were blocked. The prosecution, last minute, brought a Bitcoin witness. They paid $55,000 for that testimony. And he talked about Bitcoin, and Roger Ver had this to say about it. He said, the prosecutors in the Silk Road trial have no clue how Bitcoin works or are intentionally lying about it. There were a lot of problems with that testimony. And of course, we wanted to bring our own Bitcoin witness to challenge it. And Andreas Antonopoulos was ready to come down and do just that. And he was told, don't get on that plane. You cannot testify. One of the reasons? The jury understands Bitcoin just fine. It would be irrelevant and unnecessary to explain it further. The defense wanted to bring a computer witness expert from Columbia University. There were a lot of questions about the integrity and the procedure of the laptop investigation. It was a multi-agency investigation. Some of them did not follow the guidelines or protocol. The laptop crashed in the middle of it. There was a lot of stuff that happened. He could have explained that, challenged it, explained other technical issues involved, and also how hidden websites are very complex technology. It's almost impossible to prove anything. No, that will not be allowed because this case doesn't require special technical knowledge. So, here we were with no witnesses, too. It was a very controlled narrative. The jury was allowed to hear what the prosecution wanted them to hear and could not hear what they didn't want them to hear. And there were several examples. I just want to show you two of them. One is that same FBI agent, Christopher Tarbell. He was the head of the investigation. He signed the criminal complaint. He was the head of the arrest team, and he claimed to have found the server. He didn't show up. He was erased. He was barely mentioned. And the jury, I'm sure didn't have any clue who he was. But then, of course, then he couldn't be cross-examined about the server or anything else. Another thing that was erased was Ross's libertarian views. They were not allowed to be mentioned at trial. And I think that it's because Ross says that he created Silk Road as an open market, free market experiment to give people the experience, a real experience of a free market. The judge rejects that that's the reason. I know it's true because Ross has talked to us about this idea for years before Silk Road. He designed a video game where people could play and have that experience. He lectured about it at UT and at different meetings around Austin, and he had talked about doing a YouTube course on it. I know that and he's told me since. I know that's what Ross was doing. It wasn't about being a drug kingpin. But that was not allowed. That was erased. That was not allowed to be mentioned at trial. Doesn't fit the picture. So there were things that were left out, couldn't be mentioned, prohibited, and then there were other things that really shouldn't have been in there that were. Most obvious, uncharged crimes of murder for hire. Never charged, never convicted. Just talked about a lot. And just to be clear, here's a quote from the prosecutor, from the transcript. The defendant has not been charged for these attempted murders. But then he goes on to talk about it for about a day. It completely poisoned the atmosphere and prejudiced the jury. Of course. Yeah, of course. So it was very useful. It deprived him of bail. It deprived him of a witness list, and it basically helped convict him. And later, it would justify the draconian sentence that he was given. So I could go on, but basically, Ross was convicted of 7 charges. But then we found out 2.5 months later that some very important evidence had been precluded from trial that the jury was not allowed to hear about. Mainly, there were 2 federal agents who've been main undercover guys and computer experts, by the way, who had been on Silk Road undercover for 2 years and had been stealing almost $1 million. But besides, and that was not allowed to be mentioned, but besides that, they had basically the keys to the kingdom. They had the ability to change administrative passwords, reset PIN numbers. They had the ability to access accounts, including DPRs, and control it. They could change anything on the database, including messages and texts in the forum and the marketplace. They could manipulate logs, chats, private messages, keys, posts, account information, and bank accounts. And it's still unknown, the extent of the corruption, because even though they have both pled guilty, and pretty much it's over, there's a bunch still sealed that the government has not unsealed. So there's still some more to be known, and we don't know the extent of the corruption. Obviously, this casts great doubt on the integrity of the evidence. But to me, okay, there's corrupt agents. I mean, that's a scandal, yeah. But the real scandal is that this was precluded from trial, that the jury was not allowed to hear it, and it deprived Ross of a fair trial. The reason, and the defense and prosecution fought about this pre-trial in court before the judge. The reason they gave was, well, it will jeopardize our investigation into the agents. So the defense said, okay, fine, we'll put off the trial. We'll just, a couple months down the road, we'll do it. You get your investigation done. Well, there's these scheduling problems, and the citizen has a right to a speedy trial. Also a fair trial, I might add. And the judge said, yeah, we're going to preclude it. They cannot know about this. What's really bad is that later we found out it wouldn't have jeopardized their investigation at all because those agents knew they were under investigation. They had already been interviewed by law enforcement. So that was a bogus excuse. Jury didn't get to hear it. So we go on to the sentencing. I'd like to go over what Ross was sentenced for so you can see there's nothing violent in here. So the first is he was charged with the distribution of controlled substances on the internet. Not that he did it, but that people on Silk Road did it. And for this, he got life in prison without parole. Yeah. This is this judge's 4th life sentence this year. We were shocked because even the prosecutors didn't ask for life. Then, engagement in a continuing criminal enterprise, or the kingpin charge, life without parole. Just in case he lives a really, really long time, I guess. Now, this charge requires that the defendant committed a series of federal narcotics offenses with 5 or more people who he organized, managed, or supervised. And yet, evidence never established that there were 5 people, distinct people, involved as subordinates. They were never named. So this judge sentenced him to life with a statute that wasn't satisfied. Also, our lawyer said this charge isn't ever used for someone like Ross. He's equivalent to a landlord, where someone might be doing a drug deal in their house or in their place. And it's never, ever been used that way. It's totally unprecedented. And by the way, I recently read that social media sites, including Twitter, including Facebook, have been criticized for allowing a massive illegal and counterfeit drugs market. So I'm waiting for Mark Zuckerberg to be indicted. I'm not saying he should be, but just wondering. Next charge, conspiring to launder money, not that he laundered it, but that other people did. Conspiring to traffic in fake IDs, 15 years, not that he did this, but that other people on Silk Road did. And just for, the cherry on top, 5 more years for conspiring to commit or aid and abet computer hacking. Not that he hacked into anything, but that people on Silk Road sold software that might be used to hack into computers. The sentencing hearing itself was quite an experience. Dragged out the murder for hire again, dramatically drove the sentencing. She used this as a justification for this draconian sentence. Never charged, never convicted. I thought a sentencing was to address the convictions that were examined at trial and voted on by a jury. No, they brought those in. And then the government brought in a whole new thing that wasn't even mentioned at trial, which is that they claim that 6 people died of drugs they bought on Silk Road. And besides which, they brought in the parents of 2 of those people. It was very heartbreaking. It was awful. I mean, I totally felt for those people. It's a horrible thing. Ross did too. It's awful. But I really question that kind of emotionalism has a place in a courtroom. It should be based on facts and evidence. And that's why if you're a friend of a victim or a family member, you don't serve on the jury. So to counteract this, to respond, we hired a forensic pathologist for $9,000. I'm still paying him off. And he has had hundreds of cases, 30 years experience, and he went through each of these alleged deaths or alleged, overdoses, and he concluded that it's categorically, scientifically impossible to determine that these people died of drugs from Silk Road, that they died from the drugs that were alleged that they took, or that they even died of drugs at all. One of them had been in the hospital with pneumonia. One of them could have suffered a stroke. The judge said, that's not relevant. That's not the question. The question isn't how they died. And I'm like, oh, I thought that's what we were talking about. Okay. The defense also brought forward academic research that had determined that Silk Road actually had saved lives, that the harm reduction that was done in the drug world, that it had saved lives. She brushed that aside too as wrong. Since then, an enormous study has come out called the Global Drug Survey of 100,000 people, came to the same conclusion. Silk Road saved lives. A couple of the aspects of the sentencing I found particularly disturbing. It was very political. First of all, I felt like I was listening to a political speech when I was listening to her sentencing. She's invoking the flag several times. She's talking about democracy across the land and whatever. And then she went and attacked Ross's political beliefs and used them as to bolster and to justify this sentence of hers. She called them troubling and dangerous. We have a First Amendment. You're not supposed to be punished for your political beliefs. They're protected. Found it very disturbing. And then, of course, it was a very strong endorsement and doubling down on their drug war and making Ross the poster boy for the drug war, making him an example and saying, you're an example, so he has to shoulder the burden, basically, for not only himself, but for everybody else who they say is breaking the law, that he has to serve his time and everybody else's time who they haven't caught yet. And this is wrong. We're supposed to be individuals in this country. We should be judged on and sentenced on our individual actions. That is the hallmark and the goal of our justice system. And that's not what's happening here. He's being punished for being high profile. And I think it's wrong. So this sentence sent shockwaves around the world. I mean, it was just shocking. It is. It's so draconian. I mean, people wrote about it. Jeffrey Tucker called it deeply tragic and one of the most egregious injustices he's ever seen. Henry Blodgett, who's the CEO and editor-in-chief of Business Insider, wrote an op-ed about it. He said, this sentence won't deter other people from using drugs or protect society or serve justice. It will just waste another life. Brian Dougherty, senior editor of Reason, called the sentence horrendous injustice and absurdly excessive. Andy Greenberg tweeted, he was there, and he said witnessing a judge taking Ulbricht's life was brutal. And it was brutal. That's how it felt. Glenn Greenwald of The Guardian tweeted that the sentence was sadistic and inhumane. And he said he had some words about the judge as well. And Nick Gillespie, editor-in-chief of Reason, tweeted that we should put Ross Ulbricht on the new $10 bill. He's paying for all our futures with his life. And lots of other people wrote articles and commented. And there were some comments that the Southern District and the federal government, they just didn't like them. And so they issued a grand jury subpoena to Reason.com for private information of some commenters that they claimed were threatening the judge. So basically, the federal government moved to force a website to help them track down people who said things they didn't like, to prosecute them and potentially put them in prison. And then they said, please keep this secret. And in fact, we're going to issue a gag order so you have to keep it secret. I'd call this censorship. They issued a gag order. And the thing is, even if, no matter what comes out of this whole thing, ultimately, the intimidation is in place. And it seems to me that it's very probable that a lot of websites will now look at their comments and censor comments more diligently, and that commenters will self-censor. So how big a step is that from obnoxious comments to political speech, hate speech, as someone mentioned today? It's a baby step. It's really serious, and I feel like these people are revealing who they are. And the other aspect, well, basically, okay, so that's that censorship fallout. So it seems to me that the government is sending us some very clear messages through this case. One is, we can put you away using digital evidence. No matter what you think of their digital evidence and whether or not you believe it isn't really the point. It's the standard of evidence has been substantially lowered by this case. Digital evidence is malleable, it can be edited, it can be planted, it can be faked very easily. Mortgage companies will not accept a screenshot of a bank statement because it's so easily faked. Other courts have thrown out screenshot evidence, but not in Catherine Forrest's court. It was accepted all the way through. Another message, one person can be held responsible for the actions of another. Again, none of the charges against Ross were for anything he actually did himself. It was all about what other people did on the website, and also no charges were related to causing direct harm to anyone's life or property. They've also sent the message that if you want privacy, you're probably a criminal. They said that in their papers. They said if you use Tor, you have criminal intent. And the Fourth Amendment protections do not extend to the digital world. Now, the Fourth Amendment prohibits seizing something and just rummaging through to see what you can find, going on a fishing expedition. You can't go and get a warrant for a file cabinet and then go looking through all the files and say, oh, I found this. You have to have a warrant for that particular document. It's a particularity requirement. And yet, with digital material like laptops and phones, they're basically saying, well, that's different, and we can just grab a laptop with a general warrant and then see what we can find. It's not protected. Now, I would suggest that a laptop is like a file cabinet on steroids. You know, it's got everything plus connected to other accounts. I mean, it's hugely informative. And this is a really important question for the digital age. This is something that really needs to be, and it has been addressed in the courts, but in this case, that's the kind of warrant they got, and that's what they did. Of course, if you make a comment we don't like, you'll pay. We'll use your political views against you, and we will continue to wage the drug war with all our might. Never mind that it has not stopped anyone from using drugs in over 40 years. Never mind that it has cost billions of dollars. Never mind that it has our prisons bursting at the seams with nonviolent offenders who, are just choking our prisons. They're crowded and just full of people who are nonviolent. And they're just going to keep on doubling down despite the shattered families and the ruined lives. They've made that very clear. Well, we have these messages from the U.S. government. I have a message from somebody else, from Ross, to you. Yeah. So it's up here. There's a couple of redacted parts just for wording. It doesn't really, the lawyer, they're very particular about wording, but it doesn't change the meaning, so I'll just read it. Hi, Porkfest. I'm writing you from my cell in New York City. Sorry I couldn't make it this year. Something came up, right? Unfortunately, the worst case scenario has played out for me, and I've been sentenced to spend the rest of my life in prison. I'm an eternal optimist, though, and will never give up hope for my release. And I won't either, by the way. I have confidence that the appeals court will recognize the errors by some and outright corruption by others in the government and give me some kind of remedy. It could be a new trial where hopefully the whole story can be told, or the case could be dismissed altogether. In many ways, my struggle is just getting started now that it's going to the higher courts. So I still need your help. Mounting an effective appeal is not easy. I'm confident in my team, but there's only so much we can do without your donations. What we can be sure of is that the federal government or the government will spend as many of your tax dollars as needed to keep me behind bars. So please help however you can. I hope my story has shed light on some of the issues we face these days. There are many, but please don't let what's happened to me lead you to despair. Keep standing for liberty and respect for our rights. Keep fighting for your freedom, and eventually we will win. Cheers, Ross. So we got those messages from the government, and I want to encourage you to help me send them a message back by helping us win this appeal. Not just for Ross, but for us all, and to push back these precedents. If you're against this disastrous drug war, this is a major battle in that struggle. If you want to defend your constitutional rights, this is a good way to do it. I sincerely believe that we're at a crossroads in history. We've left the 20th century and we're careening into the digital age. We're moving at lightning speed. And what happens now, the laws and precedents that are put in place now, are going to impact us all. Ross is at the tip of the spear right now, but we're not far behind. And we need to make sure that our freedoms are protected. We can't not fund this appeal alone. We're just one family and not a wealthy family. It's incredibly expensive to take on the federal government. And we are so grateful for all the help we've gotten, donations, and just energy and time. We really are. We couldn't have gotten this far without it. But there's a long way to go still. And so we really need your help to send back that message. So please go to freeross.org and just do what you can. it's really important. It's a great opportunity to step up for freedom. Thank you.